Hello, hello, hello. It's Attorney Mike Grevlin coming to you from Chicago as usual, and I wasn't going to do it, but two things came up. First of all, we had development in the Kim Gardner debacle. Everybody sent it to me. I don't have a lot. I just thought I should acknowledge it because it's strange. We were just talking about it, and now we've got a resignation out there. So I'm gonna just start with a short clip of that. And then I was just kind of scouting stuff, and I got some stuff from a call in Thurston County, and of course, all of it's interesting, but one woman in particular, I can't help it. I get too excited, then I got to share it with you. I do. That's what happens. All right, let's do it, shall we? Well, actually, I should set up the first one. The first one, I did a video. There was a contempt hearing. Kim Gardner and an associate got held in indirect contempt. And today that the assistant, what we call him state's attorney, I can't remember what they call him, whatever, the assistant prosecutor that was there who had the bad attitude with the judge resigned today. So that's what we're going to start off with.
Okay, so in February, Circuit Attorney Kim Gardner had 6 prosecutors assigned to her violent felonies unit, which even then some say wasn't enough. Each of them had more than about 100 cases assigned to them. Now, there's only one after Chris Desolitz confirmed to me this morning that he is resigning.
A Zoom call. If you could unmute yourself and come on.
Okay, here, I can't remember this judge's name. If you know it, put it in the chat for me. He's been on the channel, I don't know, at least 10 times. He's a decent guy, but I'm feeling sorry for him today. Nothing's terrible. It's just everything's a face palm. Everything is a face palm, start to finish.
The Zoom call there, Mr. Brockhagen. I'll take you up in just a minute here, ma'am. So, Mr. Brockhagen and Ms. Make sure I get the name right. Ms. Mack, you're here because you're asking for an order against another individual, and then you're asking for a temporary order, and then only one side is present. Whenever these cases come in front of me, I can go one of three ways on these. I can either grant the temporary order, which will take effect once the individual is served, or and then that set a hearing within 14 days of today's date. Would have to reappear at that date, and then a judge will hear it's whether or not the order here from both sides, and then determine whether or not the order will be extended for a period of a year. I can also look at and set it for hearing, which says there's not enough to enter an order here right now.
This guy, by the way, is reasonable as all get out. The litigant here, he's perfectly reasonable. It's just the facts. It's crazy.
But we'll set it for hearing, and again, other side will need to be served, and then we'll reconvene, and then we'll hear again from both sides to see whether or not an order will be entered at all. And then, of course, the third opportunity I have is simply to deny any sort of order or any sort of hearing on its face. So, Mr. Brockhagen, I'm going to start with you. Can you describe for me a little bit your interaction there with Courtney Albin? How did this all come about?
So as briefly as I can, she appeared on our doorstep last Saturday, not this past Saturday, but the one before. I'm not sure of the date. I think that was the 22nd. And both my wife and I were gone. We drove into our driveway. She was just standing on our doorstep. I asked if I could help her. She, kind of came up with a story that she thought she saw a dog walk onto our property, wanted to know if it was ours. I told her we didn't have a dog, and she basically turned around and left. There was another incident Sunday night, late Sunday night, early Monday morning. in which both my wife and I woke up to a loud sound on our door. It turned out that there was a rock thrown at our front door. I couldn't.
Somebody tell me, is there more to this story, or is this just flat crazy? Is it what's going on here?
I don't know for a fact that it was her. I didn't see her. We didn't have video surveillance up at the time. And then on Friday night, which was excuse me 1 second. Yeah, so Friday night, the 28th, at that point, we did have video surveillance up. Again, she approached our front door, tried to open it. We immediately called the police. The police had been called after the incident Sunday night. And the police ended up responding within about 5 or 7 minutes.
Thank you.
They could not find her anywhere. So
you're right.
We did tell her to leave. I told her to leave over the intercom of the security system. And she did leave when I told her to. And then on Saturday, I was away from the house briefly to run an errand. At this point, we had another security camera installed, and I got a notification that there was a trigger on that security camera. I knew my wife was outside playing with our 2.5-year-old son and also had our daughter with him. And I assumed that it was my son setting off the camera, and I pulled up the notification, and she had entered the property again. I immediately called my wife, told her to grab the kids and run inside and call 911. She did so, and I arrived home within a few minutes and ended up confronting the individual at our back door, and she was trying to force entry into our back door again. And my wife was already on the phone with dispatch. And
okay, if now I'm just reading the subtext here, but if it's an infatuation thing, where did it come from? Is it just out of whole cloth? Or did we have some prior flirtation? I mean, I don't mean to, this guy seems like a really nice guy. So I'm not like trying to throw shade on him. I'm just saying, make this make sense to me.
And the police ended up coming and eventually arrested Courtney or Miss Albin.
How do you know this person?
We have never met her or seen her until Saturday the 24th. She just seems to, for some reason, be fixated on our property and our house. When I confronted her,
is she in custody now? You had said she was arrested. Is she in custody now, or do you know?
She is currently in custody at the Nisqually jail, and I believe her hearing is set for 2 p.m. today.
Give me just a minute.
I mean, that's what's scary. I don't think he does either. I don't think he does either. Yeah, I mean, he may have just had casual contact, literally been viewed walking through the neighborhood, and now he's got this on his hands.
Might be Superior Court. Okay, so what I'm going to do today here, Mr. Brockhagen, based on your petition combined with your comments there, I am going to find that it's appropriate to enter an order at this time. So it'll be basically an anti-harassment order. The provisions of the order are she's not to do you commit any harm against you or your wife. She's not to contact you in a way, not to come within 1,000 feet of you or your residence or your workplace. But I don't, based on what you said, I don't imagine she has any idea where you work. I wouldn't think.
No, she does not. I work
in any case. And then this sets a hearing for May 15th, 2 weeks from today.
Okay.
So this order will take effect once she's served. It's going to be your responsibility to get her served. You can either serve her through a process server. You can contact law enforcement and hire law enforcement. I'm not sure how you want to go about doing that. However you do that, though, but it'll be need your responsibility to get her served. And it basically can be anyone but you and your wife. You can't serve her yourselves. Correct. You need to get someone else to do that. Do you understand that?
Yes.
And then we'll reconvene here 2 weeks from today.
It is
And
sad.
then a copy of this will get emailed to you with the service packet. And then, like I say, it won't take effect until this person is actually served. And then we'll reconvene 2 weeks from today and see where we go from here.
Okay. Thank you, Your Honor.
And that's it for today. And then you'll get a copy of this. Like I say, it should get emailed to you here by the end of the day.
Okay. All right. Thank you.
Sure. Mr. Gasling, I'm going to have Ms. Mack come in here and sit at that table for just a moment. Then we'll get going on the in-custody calendar.
Yeah, that's freaky. But
And Ms. Mack, could you come up, please?
the right thing happened. Here we go. All of it's kind of interesting, but this is my fave.
Want me to sit right here?
Either one of those chairs.
Quality.
Yes, ma'am. So I'm having some trouble figuring out what this is all about.
Yeah, you are.
I kind of feel the same way. Why they don't like me, but
I mean, what specific, harassment covers a number of things. There's a
Yeah.
definition of it.
well, what,
And what I'm asking is, what are these folks doing to you that you consider harassing?
okay, I had a unbumpable lock put on my door because people were trespassing.
A what? I'm sorry?
Unbumpable lock on my door because people were
You're
trespassing.
gonna have to repeat that word. Un what?
Unbumpable lock.
I don't know what that
Meaning
is.
You can't get into it unless,
Judge doesn't know what that is, and that's a you problem, not a judge problem here.
it's one of those safety type features for
Well, I mean,
No.
that applies to any lock, doesn't it? I mean, you can't get into it unless you have the key or the combination or what have you.
well, it's a special kind of lock is what it is.
Well, continue on, please.
Okay. And I had that put on because people were trespassing into my apartment, like I had a revolving door. And so then all of a sudden, people were continuing to trespass. And the only person that had a lock is the staff members, the landlord.
So are these staff members or landlords?
Yeah, they were breaking and entering into my apartment. And they hooked up, vape is blowing into my apartment all hours of the day. They're trying to run me out of there. They actually gave me an eviction notice that had no bearing whatsoever. And that was like in 2021. And
So you're telling me that they've hooked up something that's sending vape fumes into your apartment?
yeah. And have to have an inhaler because of it. They're trying to run me out of it. This is my vape right here. I mean, my
That's your inhaler.
yeah,
It's
my
not
inhaler. And so she's yelled at me. Cindy Pug has yelled
Pew.
at me. And other people say that they've yelled at her too, at them. And
How long have you lived there?
Other people said that they yelled at them too. This judge is cracking me up tonight. He's usually really straight-laced, but he is struggling to get through this hearing.
I moved in June 1st of 2021.
I see.
Yeah, so almost 2 years.
And then who do you have with you? You're with Ms. Mack, ma'am. What's your?
Yeah, she's a friend of mine. She drove me in. So, and I have all kinds of recordings that they have had loud noises from the gal that lives in 424. There's all kinds of.
I don't know who's the. Again, I'll use your words. Who is that individual?
See, I asked the manager her name. She wouldn't give that to me.
Okay. All right.
And so she says, I can't give that to you. But
Yeah.
the bottom
For good
line
reason.
is the staff members are telling her to make all these noises because they don't like me. I'm not a doormat. I'm not stupid. Like with the eviction notice, I knew there was no bearing for that. And they stalk me. wherever I am in my apartment, if I'm in the restroom, I can hear them making noises above me just to belittle me. Or if I'm in they have the vape coming through the exhaust fan in the bathroom. And I didn't have asthma before all this started happening.
And these are the people who own the building or the landlord?
The landlord gave her asthma. Come on.
Managers?
They're the managers, yeah. And
Do you think that, I mean, I'll be frank with you. I'm finding this very difficult to believe, but you can continue. I'll allow you to continue.
Well,
Some of these things.
My doctor knew.
Well played, Judge. It was nice. It was professional. It was polite, but it was frank. I liked it.
For a fact, she's got records saying that I never had asthma until all the vape is blowing in there. And you know, they stalked me outside. They like to intimidate me. They don't want me there because they've had tenants that actually attacked me on their behalf, yelling at me and all kinds of stuff. And it's just getting to be too much. And that's why I'd like to have a restraining order against these people. They use a hammer. And you know, how are you supposed to sleep with people upstairs hammering on the floor?
Yeah.
And
some of what you described,
I
frankly,
have recordings of that.
is that's the nature of apartment living. Sometimes, you know, when people are working on other apartments or what have you, or if they're working on with a hammer and saw or power tools, that's going to make noise.
That was at night, hammering on the. No, they weren't working at anything. They're trying to get me out of there.
They're triple nice, Judge.
All right, ma'am.
And then she lied to me. She said that this gal goes to bed at 5, and all the noise was after 5, at 8 o'clock. That's what she does. She lies. She bold-faced lies. And the Fairfield, the
judge was absolutely holding back. I think maybe you lie.
people that manage it, they are backing them up. And it's just it gets to be too much for me because I pay their salary by paying my rent, and I pay monthly. And this is the thanks I.
All right, I pay their salary. She might qualify as a Karen right there. I mean, she was teetering on the edge the whole time, but I think that puts her right over.
And yeah, you're right. A lot of it doesn't make sense.
Yeah.
I went to a potluck. I have things in my freezer that you can test that made me sick at a potluck. I was the only one that got sick that day.
Judge, have things in my freezer you can test. It's like the old joke. Oh, this tastes terrible. You want to try it? Oh, poor Judge. He's doing fine, but he's on the struggle bus with this one.
So are you? All right, ma'am, here's what I'm going to do here for today. Okay. So I'm not going to enter an order. I will set it for a hearing. Will be a notice for hearing. No order is going to be affixed. So whoever the judge is will hear from you. They'll hear from the other person. And then a decision will be made as to whether or not an order should be entered at all. We'll hear.
I'm leaning towards no order entered here. I'm not a betting man, but if I were, that's where I put my money.
We hear both sides and go from there.
All right.
All right.
Okay.
And so, did you provide an email address, or if you could wait outside, someone will bring a service copy, and you'll need to get both these folks served. And you cannot be the one who does it.
Right.
You need to get either hire someone to serve or something else, and that a judge will determine, but whether or not an order should be entered at all.
Okay.
But again, I'll just leave it at that. And so we'll set it for hearing. So wait outside. Someone will bring you a service copy here before too long.
Okay, thank you.
Sure. Thank you, Mr. Gaslin. You can resume your place at the table there. At the Thurston County Correctional Facility, we'll start with you. What's your name? In the blue.
Joshua.
And I need you a little bit louder, please.
Josh Mitchell.
This is Mr. Mitchell.
Yeah.
Joshua Mitchell, I believe your honor.
Right, that's what I said. I think. And Mr. Gasling, are you here with?
Yes.
Okay. So this is, looks like a preliminary appearance, and then there's a backup case. So on 23 DV 0504, it looks like a new charge.
So, Your Honor, and I did have a chance to go over that case with Mr. Mitchell. No objection to probable cause for the purposes of today's hearing only. We would ask that Thurston County Public Defense be appointed on this new case. I see that Attorney Kale was already assigned on that backup matter. It's my understanding that Mr. Mitchell's financial situation has not changed and he hasn't been working for several years.
And for what is the state seeking probable cause, Mr. Dinelli,
Yes, Your Honor, just a moment.
on the new charge? Is it violation of a no contact order?
That was my
Yes,
understanding, Your Honor.
yes, Your Honor, it's a violation for no contact order, and the state also believes that the defendant needs a designated crisis responder.
Okay, well, we'll get to that. I just asked
Yeah.
okay. So, Mr. Mitchell, looks like he has a change of plea date set on May 26 on the other case. But on 23 DV 0504, there's a new charge of violation of a no contact order. I will find probable cause for that. I will appoint Thurston County Public Defense to represent you. We're going to set conditions of release on the new charge. We're going to set a date for arraignment. I'm not sure where the state wants to go on the old charge or not. I want to make sure that I'm right, that there is a court date set on the older charge. So, Mr. Gasling, did you wish me to advise him of his rights?
I did have a chance to go over his rights. I believe he understands them, Your Honor. So thank you.
So, Mr. Denali, what's the state's position on conditions of release?
Your Honor, Your Honor, the state is requesting that if the defendant is to be released, that he undergo a designated crisis response evaluation prior to his release.
Go ahead.
Yes, I mean, so, if it is going to be a PR release, we do recommend that he go through a designated crisis response.
Well, is the state requesting bail or no?
Yes, Your Honor, the state is requesting $2,000.
And what's alleged? Okay, hang on. There probably. Give me just a second. Mr. Denawi?
Yes, Your
No,
Honor.
Mr. Gasling. I'll hear from you on conditions of release.
Your Honor, I would request a PR release for Mr. Mitchell. Based on what's been alleged in the police report, it does seem like the alleged violation was invited by the protected party, and recognizing that is not a defense to
The victim asked for it. Oh, gotta be careful with that one.
the charge. I do believe it can be considered as a mitigating factor here.
Where did it say that?
Mr. Mitchell has not been working for several years. Any amount of bail that would be imposed, I do not believe he would be able to afford it. I would ask the court to take into account his financial situation. And as I understand it, Mr. Mitchell does have a fairly serious medical condition that was recently diagnosed. He has not had access to any of his several medications while he has been in custody. I believe that his health is going to continue to decline if he is held on bail. I would just ask the court again to also take that into consideration. He does have a future court date. I did not see any warrants in his history, so I do not believe that there's any cause for concern that he won't appear to court when he is required to.
Is any input from the victim's advocate from his brother, who appears to be the protected party here?
Your Honor.
And is his brother on the call at all? Ms. Higginbottom, have you had any input from Mr. Justin Mitchell?
I did speak with him today. All he informed me of is that his brother needs some mental health help.
Say that again, please.
I did speak with the victim today, and all he informed me of was that his brother needs some mental health help.
Yeah, did he give any input on, safety concerns? Do they all live with sounds like the father is the home where Justin was, where Joshua came to. Do they all live together, or they used to?
Based on what was written in the report, it looks like that there were some separate residences on the property.
Mr. Denau, you wanted to say something?
No, Your Honor, that the state is actually okay with him being released on his personal recognizance. However, we do recommend that he be put under pretrial services supervision, Your Honor. And again, the designated crisis responder evaluation.
So, Mr. Mitchell, can you hear me here?
Yeah.
This is a bummer.
Can I rely on you to stay away from your brother for the time being?
As long as I have a place to live or something, yeah, but right now I'm homeless. I really need to be in the hospital.
Do you want out or not? That's what's sad. That's what makes me think he really has real problems. Because anybody with two brain cells to rub together knows that the right answer to that question currently, to leave incarceration, is yes, I can stay away from him. Thank you very much, Judge.
Hospital or something, because I was told I was terminal.
So here's what's going to happen today here, Mr. Mitchell. You're going to be released, but we're going to set a court date fairly quickly, and you need to be back here on May 10th. You understand that?
Okay.
May 10th at 9 a.m. for your arraignment on the new charge.
Okay.
Conditions of your continued release are: don't have any criminal law violations, comply with any existing no contact order, and I also want you to report to an organization called Pretrial Services. Do you understand that?
Yeah.
And then you need to be back here on May 10th at 9 a.m. I'm also going to require that before you're released, you're going to be interviewed by someone referred to as a DCR, as a designated crisis responder. They're going to talk to you about maybe the concept of some sort of, full voluntary civil commitment or something, which could get you in a hospital to get the care you need.
Okay.
And then the other condition, the other case, you'll be released on that also with the DCR review. All prior conditions remain. We'll set that for a backup on the same date as arraignment. And it sounds like a disposition is in place. You may want to speak with Mr. Kale. Maybe a disposition can be entered. I don't know. But that's it for today there, Mr. Mitchell.
And Your Honor, will that information be able to be printed out at the jail and given to Mr. Mitchell before he...
I hope so. I've been, and can someone from the Thurston County Correctional Facility verify for me that he'll get a written copy of these judgment and sentences before he's released?
Yeah, this is Deputy Zervadakis. He will get a written copy of everything.
Perfect. Thank you.
Thank you.
What's your name out at Nisqually?
Michael John Bevich.
I sure do.
And I'm also appearing for Mr. Bevich.
Thank you. And then this is a preliminary appearance also.
Yes, Your Honor, I did have a chance to review the case with Mr. Bevich, and I do believe he understands his constitutional rights as well. My understanding, well, apologies, I'm a little rusty on the probable cause. Would you like to ask?
And for
the
what is the
first?
state seeking probable cause there, Mr. Denawi?
Yes, Your Honor. The state is seeking probable cause for theft, domestic violence in the third degree, domestic violence.
Theft, domestic violence?
Yes, Your Honor. Well, because he deprived his girlfriend of her key by taking it out of her hand forcefully while she was in the car.
Your Honor,
She got stuck in the park.
Okay, so just hold on there, Mr. Bevich. I'll give you a chance here in a second. Are you stipulating probable cause?
Your Honor, no objection to probable cause for today's hearing only.
So for today, Mr. Bevich, I'll find probable cause. We're going to talk about conditions of release. Is he seeking court-appointed counsel?
Yes, Your Honor. He does receive food stamps, has not had a steady job for the past 2 months, and I believe would qualify on that basis.
All right. So I will appoint Thurston County Public Defense to represent you. We'll set a court hearing for an arraignment. It'll be a week from Wednesday on May 10th. We're going to set conditions of release. I'm going to hear from the state, and then I'll hear from Mr. Gasling. Go ahead, Mr. Denawi.
Yes, Your Honor, the state is okay, does not object to him being released on his own recognizance. However, we did submit a no contact order, which is in Laserfish, and we asked that he comply with the no contact order and not to carry any dangerous firearms or weapons, and to commit no new criminal law violations.
Mr. Gasling.
Your Honor, he's charged with a non-violent offense here. It's a theft 3, and as Attorney Denali mentioned in the police report, it's alleged that he took car keys out of his partner's hands. So I would object to the imposition of a no contact order. And they live together. I'm not seeing really the basis for a categorical prohibition on contact here. Perhaps if the court was willing to consider instead an anti-harassment order that would permit them at least to live together or apart. As I understand it, Mr. Bevich does have another place he can go. However, I would ask the court to not restrict his freedom of movement to the extent that a no contact order would.
Your Honor.
I'll give you a chance. Just a minute.
I don't know if I have that hearing. I probably should have hung on for that one
Your Honor, if I may speak.
because it looks promising. I'm not gonna
Bevich,
lie.
I'm going to advise you not to speak, not at this hearing.
Okay. So, Mr. Bevich, I'll come back to you in a second here. Ms. Higginbottom, do you have any input from what could be the protected party?
I was not able to get a hold of her today.
Okay. So, Mr. Bevich, I'm not sure what you want to say. I don't want you to talk anything about what's alleged to have occurred here a day or two ago. I know and I'm going to stop you, even if you try and stop about that. But, you know, the person, the public defender who's here for your behalf has advised you not to say anything. But, again, thoughts?
Nope.
Okay. And then Mr. Gasling, you said they live together, but he has a place to go for the time being?
It's my understanding that they share their home. If he has to find someplace else to go, it may be possible, but I don't have any more concrete information.
Okay. Give me just a second. Mr. Denau, you wanted to say something?
Yes, Your Honor. My understanding is that at the moment they are homeless. So it's not like they're really, I mean, they are living together, but they're homeless because, and it's due to his behavior that they lost their tenancy where they were living prior. So it's not like he's going to be restricted. It's not like they have a home right now that they're living in.
So, Mr. Bevich, what's going to happen today is you're going to be released on your personal recognizance. I'm not going to set bail. Conditions of your continued release are don't have any criminal law violations, don't possess a firearm or other deadly weapon, and for the time being, until I know more, I've reviewed the police report, which has been submitted as a part of a declaration of probable cause. I'm going to sign a no contact order for the time being. That can change as new information develops. But for the time being, you're not to have any contact with Ms. Bryant. Do you understand that?
Yes, sir.
And no contact means no contact, no calling, no texting, no emailing, any sort of contact at all would be a violation. You're going to get a copy of this order, which is going to give you your court date. Your court date is 9 a.m. a week from Wednesday on May 10th for your arraignment. I would encourage you to speak with your attorney at some point before then. Contact Thurston County Public Defense and then find out who your attorney is. I'd wait a few days. It'll take a few minutes for them to sign that. And then we'll see you back here on May 10th.
Your Honor,
Okay.
may I request on that no contact order, to the extent possible, can a civil standby be put in place, even if it is not for a static residence? Can he be permitted to,
How is that going to get set up?
that if
What
they're,
the hell?
again, I'm operating with very little information on where they were living.
A civil standby for a non-static residence. He needs to say he can go to this location one time and get his stuff, but there is no location. This is a weird request. I don't get it. Somebody explain it to me.
Whether personal property is in a shared vehicle or something like that, but if he can
Shared vehicle?
coordinate, at least to the point where he can get some personal belongings.
Can
that
I
he
go to the
needs,
van?
before going and trying
Oh.
to find someplace else to live. I'm sure that would be very helpful to him.
You can discuss that as his arraignment until you find more information, but I don't know how that could be set up. Anyway, okay,
I'm feeling this judge today. He wanted Karen to just leave. He's like, fine, we'll have a hearing another day. We'll run along. And this one, he's like, no. I'm not going to hurt my brain cells over how we set up a whatever.
that's it for today there, Mr. Babbitt. You can get taken back.
Thank you.
Little Seahawks.
What's your
flag
name there at the Thurston County Correctional Facility?
Aaron Kiska, sir.
Say that again, please.
Aaron Kiska, sir.
Oh, Aaron Kiska, I believe.
Oh, your name. Oh, I see. You're saying Kiska, sir. Okay. Your name is Aaron Kiska.
Correct, sir.
Thank you.
Oh, there he is.
Mr. Gasling, did you get a chance to speak with him?
I did, Your Honor.
He's here on a charge of DUI.
Yes, Your Honor. And so I did have a chance to go over the case with him and review his rights. I do believe he understands them. Defense has no objection to probable cause for today's hearing. Only would ask the court to enter a plea of not guilty and to appoint Thurston County Public Defense. Mr. Kiska does receive food stamps, and I believe would qualify on that basis.
I do
Mr.
too.
Kiska, you're charged with one count of driving under the influence of alcohol and or drugs. That's a gross misdemeanor, which carries with it a maximum penalty of 364 days in jail and a $5,000 fine. To that charge, a plea of not guilty will be entered. This matter will get set for future hearing. I will appoint Thurston County Public Defense to represent you. And we're going to set conditions of release. I'm going to hear from the state. And then I'll hear from Mr. Gasling. What's the substance alleged to have been consumed as a,
Drugs, Your Honor?
I'm sorry?
Drugs?
Do we know what, that covers a lot of ground there.
It may have been fentanyl or.
Okay, and I know these are just allegations. Mr. Denawi, I'll hear from you.
Your Honor, the state is requesting that he be released on his own recognizance, but to not drive without a valid license or insurance or an ignition.
This is a third within 7 years,
Well,
as I see it.
one second. I'm sorry, Ryan. I'm sorry. I was looking at the wrong case.
Oops.
Yeah. So,
Cut him loose, Judge. You sure about that, prosecutor? He seems to drink and drive a lot.
Your Honor, the state is requesting that bail be set at $20,000, and if he is to post bail, that he not drive with a valid license, insurance, or ignition interlock device, and not to possess or consume any controlled substance without a lawful prescription, and no new criminal law violations, Your Honor.
Mr. Gasling?
Your Honor, I would ask the court to take into account Mr. Kiska's personal financial situation and would object to any bail being set, would ask for PR release. Mr. Kiska has not been working for about a year and a half. He would be unable to pay for bail, and as I understand it, his spouse has also been laid off for several months, so he would not have any ability to get out if bail is set in any substantial amount. He does have that prior DUI in 2019.
Yeah, agreed.
However, would also object to the imposition of ignition interlock device. As I read the statute, that is not required because this is an alleged drug DUI, not alcohol. So would ask for PR release, and if the court is inclined to set bail, to set it at a nominal amount. Does not have any warrants. I do not believe there's any reason to fear that he would not appear to court when he's required to.
As I said, this represents a third DUI within 7 years. Had one in, looks like, here in Thurston County in July of 2016. The DUI was amended to an Neg 1. And then a DUI in October of 2019. And now this one, which I'm going to set bail in the amount of $25,000 cash or bond. If that's posted, he's not to have any criminal law violations. Don't drive without license or insurance. Stay out of bars and taverns. Don't consume any alcohol or have any controlled substances without a valid prescription. If he is post bail.
Well, there you go. He rings him up. You know what? I got a little more in me, so you guys can tell me in the chat. I need a little pick me up. I think we're gonna go over and see our good friend.
Hey, Judge Manning.
Hey, and we got Bostic, and we got the court reporter. We got a court reporter. Where's Bostic?
Can anyone tell me if anything's funny happening on there?
James, I'm turning your camera off. We got pretrial here. I don't see do we have pretrial?
I'm here.
Oh, gotcha. Okay, Bostic. All right. So we'll start with the one in ACDC. So it's Shakrisha Floyd Jones.
Yes, Your Honor.
All right. And we got Mr. Lyle. So this is position 11, 23, CP 215765, 96 days without indictment. There's a $7,500 split bond as of January the 27th. Aggravated battery and theft by taking, misdemeanor. Pretrial.
What's the name?
Shakrisha Floyd Jones, position 11.
It's not. That's not my 11. Shakrisha Floyd Jones.
Well, another
13. Number 13.
13.
18
Sorry about the
prior
numbers,
arrest.
everybody. So the numbers may be up, but it's Shakrisha Jones.
I got it. 18
Right.
prior arrests, 4 misdemeanors, 2010 battery, prior DUI, 2018 battery, family violence, FTA in 2014, open case 22 SC 184332, felony theft by shoplifting, nothing further.
Go ahead, Mr. Law.
Yes, Miss Floyd Jones is age 37. She was born in Pennsylvania, though she's lived here in Atlanta area for the last 20 or so years with her cousin and her mother. She has several children, a 23-year-old and an 8-year-old, both girls who live with her mother, and one grandchild who's a 1-year-old. So she really wants to turn back to see that her grandchild. She has a 10th grade education, has been working as a Wendy's cashier, and can return to that position once she's out of the jail. And she's an active member of the Ebenezer Baptist Church. She'll be living in College Park, Georgia, with her mother at her mother's address, which is the one on file. No, it's not one on file, but it is on Sullivan Road in College Park, Georgia. And she does have medical issues and MH issues. So we're requesting that her no bond status be given $5,000 on her aggravated battery and less than $5,000 for the misdemeanor, maybe like $1,000 for $6,000 total.
All right.
Don't
Is that in
do that to
Clayton
me.
County? Thumbs up or thumbs down, ma'am, where you be living, or Fulton? Thumbs up, Fulton? Thumbs up, Fulton. All right. Go ahead, Ms. Patton.
Yes, Your Honor. For this case, the state is recommending on the aggravated battery charge a $10,000 good bond, and it looks like the theft by taking, there was a good bond entered by Judge Hughes of $7,500. At this time, the state feels that's reasonable and fair, and that is due to the defendant's history and likelihood to reoffend.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Gregory Sanford. Stay away from 55 Peachtree Street Southwest. Going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. 10,000 count one, 5,000 count two. Best of luck to you, ma'am. Let's see. All right, ladies and gentlemen, I was doing a special set hearing, so no picking at your face, no playing with your hair, no getting up and walking out. Keep your head up and pay attention. 4 South, booth 3, shut the door behind you. All right, when I call your name, you got to wave so I'll know that you're here. You're all muted. Nobody's going to be unmuted. It's just like a bond hearing. We're addressing bond, not guilt or innocence. If I see you picking your hair, twisting your hair, mashing your zits, getting up and walking out, your case will be reset 30 days or more out. Don't put your head down. If anybody wants to fall asleep, it's me. Just got off another hearing and I got to go back as soon as I finish. So we got Fabulous Cordray. All right, 23 CP 215601. No bond as of January 21st. There's 102 days in without indictment. Count of armed robbery. Preach. Wow.
Only prior adult Georgia, or this is his only prior adult Georgia arrest. Open case appears to be in Louisiana for illegal stolen goods from an 8/14/2022 arrest. There appears to be a hold. Nothing further.
All right, go ahead, Ms. Snyder.
Thank you, Your Honor. Ms. Cordray is 19 years old. She was born in Louisiana. She's lived here for most of her life. If she's released, she'll be living with her sister in Douglasville. She has a job at NOLA Po' Boys in College Park. This incident is a 2020 incident when she was 16 years old, and the Fulton County District Attorney's Office didn't decide to prosecute until recently. She's had no contact with who would have been the co-defendant had it been indicted at the time.
NOLA Po' Boys
In the meantime,
good.
she has completed her CNA certificate, and she got a certificate of excellence and a certificate of achievement while she was completing that program. We had asked for a $5,000 bond.
Sit down, 3 South, booth 3. Sit down. All right, what says the state?
Yes, Your Honor. In this instance, the state is recommending a $10,000 good bond. That is based upon the state speaking with the victim very much still in fear, and due to the fact that she has a open charge in Louisiana, there's concern about her possibly fleeing, since that is where she has ties to, and not showing up again for court.
She also has an open charge there.
Prescribed, no alcohol, no weapons. No further contact with David Simpson. Stay away from 2841 Greenbrier Parkway, Southwest. Going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. You're also going to have 48 hours to have that ankle monitor placed on your ankle once you get released from this hold. Stay out of Fulton County unless you're here for court or to see your lawyer. Where she works in College Park, is it on the Clayton County side or the Fulton County side? Clayton County, ma'am, thumbs up. All right, stay out of Fulton County unless you're here for court or to see your lawyer. You may have to pass through Fulton County going to work in College Park on the Clayton County side. Do not run out of gas. Don't get a flat tire. Don't stop for anything to eat. Put snacks in your car. There's no reason for you to stop in Fulton County unless you're here for court or to see your lawyer. $10,000 good bond. Best of luck to you, ma'am. You can leave the booth. Thank you, Ms. Snyder.
Thank you, Judge. May I be excused?
You can. Do we have Cobb County here yet? Don't see Cobb yet. Hold on one second. What about Cortez Ragland? Wave your hand if you're Cortez Ragland. Nope. What about, let's see, no, I don't think they're here yet. ACDC. What about Byron Stratford? Byron Stratford. All right, it's my position too, but I don't know. Byron Stratford is, add-on number 2. Yeah, it's 23 CP 215525. 106 days without indictment, no bond as of January the 8th, battery, family violence, subsequent conviction or prior force felony conviction. Preach! Rah!
Mr. Stratford, 20 prior arrests, prior criminal trespass, first offender on a robbery in 2015, 2 and 21 terrorist threats, 3 FTAs, 3 misdemeanors.
All right. Go ahead, Mr. Olaf. Go ahead, Mr. Olaf.
Thank you, Your Honor. Mr. Stratford is 28 years old. He's lived in Georgia most of his life. His grandmother, mother, and sister all live here. He made it through the 11th grade. He was working at Patio Laundry. It's an overnight cleaner service that he could return to, should receive bond. The address, I submitted a change of address, which will be 2301 Godby Road. That's College Park, Georgia. He'd be living there with his sister. We're just asking for a bond. We'd like to request a signature bond, Judge, but what the court would see not to do that, then not to exceed $5,000. Thank you, Your Honor.
All right, go ahead, Ms. Patton.
Yes, Your Honor, Mr. Stratford is entitled to a bond as is his right. The state in this case is recommending for the charge a $10,000 good bond based upon his history and likelihood to reoffend. Also worried about a danger to the victim. Also, we would ask that you, if Your Honor is inclined to do a lower bond, to make sure the conditions of staying away from the victim and the incident location are in place.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Natasha Davis. Stay away from 3700 Martin Luther King Jr. Drive Southwest. You're gonna have a Teletrix monitor. Ms. Rowe, you know how to do that order, right? For Teletrix?
Yes, Judge. You want me to just, I have what I have on my my notes. It's just Teletrix monitor will be paid by Fulton County through A&A. All county monitoring, all previously imposed bond conditions.
You should be.
In place.
Right. Obviously, you don't have to put that part about previous order of bond condition, but yeah, paid through the A&A. Although they do the ankle monitors too through the ORCA, grant. I don't know why it has to say that. So we'll do a Teletrix monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. You have to supply that to the ankle monitoring company and to your lawyer.
There's my bond
You're going to live on
conditions.
the Fulton County side of College Park, thumbs up or thumbs down. All right. As long as you're going to be able to stay in Fulton County then. $10,000 good bond. Best of luck to you, sir. You can leave the booth. Cedric,
Judge,
yes, ma'am.
I'm sorry, quick question. Judge?
Yes.
Quick question. So since we're doing Teletrix,
I'm only going to do a lump sum of them.
Okay. For my 24-hour curfew with the job, I have them reporting to the ankle monitor company.
Well,
Should I put the Teletrix company?
Right, yeah, to the monitoring company, yeah. Thank you.
Okay, gotcha.
Right.
Thank you.
All right, Cedric Brown. All right, this is position 2 on the add-on calendar. 20 CP 192460. He was already in DOC custody, so I know this is 41 days on this, but there was days before this. He was returned from DOC, 2 counts of kidnapping, aggravated assault, and battery. The offense date is no bond as of 6/17/2020, and the offense date was 6/4/2020. And Mr. Butts.
Yes, I'm here, Your Honor.
All right, so I know he was in jail prior to this for this charge, and then was sent to DOC and then sent back. But right now, he's been in here 41 days without indictment.
Correct.
Draw.
And originally,
Let me see. Go ahead and hear from Preach.
all right.
I didn't look his up for some reason.
All right, then go ahead.
Anyway, his wife is online. He's been married for 10 years, and they have a stable house on Milton Avenue. He's got 2 children that need him at home, ages 9 and 6. And his wife also needs him for transportation. He has a job waiting on him when he gets out. He has a place to stay when he gets out. And he didn't do this. His twin brother's been out on bond for this since it happened 3 years ago. And while he was in jail, Your Honor, he completed an intensive RSAP program, and his only offenses before were drug offenses. And so he's done well. He's anxious to get out, join the community, and see
3
his
South,
children.
booth 3. Get back in here and sit down. Whoever's supposed to be in here, come back in here and sit down. Unless I'm finished with you, you stay in the booth. Sorry.
Was that me?
No, I'm talking to 3 South, booth 3. If I have not handled your case, you stay in the booth.
Pay attention, attorney. Come
No,
on.
Go ahead.
Is it all right for me to come back now?
No, it's fine for you, but these people aren't going to get up and walk in and out of the booth. You're in court, booth 3, 3 South, booth 3. Hey, he can wait his turn. Go ahead. Sorry.
Anyway, Your Honor, he has no failure to appears or anything. He has a family waiting on him. He was born here in Atlanta, lived here all his life, and mother and brothers, all of them live around here. So he's got, good community support. He doesn't, he still contends he's innocent and didn't do this. So what I'm doing is asking for a low bond or signature bond or go through pretrial. Any of that's suitable with him, because like I said, he has a place to stay. He has a place to stay and he has a place to live, and his wife is online if you need to hear from her.
All right. What says the state?
Yes, Your Honor. In this case, the state is recommending for both kidnapping charges a $20,000 good bond for each, an aggravated assault $10,000 good bond, and a $5,000 good bond for the battery. That is due to the nature of the charges in place. Based upon that, I didn't do the math, and I'm not going to do it now. I was going to, but that doesn't make any sense.
According to the pretrial report that was done in 2020, that was arrested in July 10th, 2014 for possession of cocaine with intent to distribute. Then it does appear to appeal probation. This was back then for possession of cocaine. That was a 13 SC case, probably not. 10 years confinement, 10 years probation for possession of cocaine with intent to distribute. Marijuana case, term 10 years confinement, terminate, not on parole. Defendant does have prior felony convictions, does not have 2 or more failure to appear, does not have 3 or more probation violations, hasn't been convicted, and more than 10 years. So,
And this case is 3 years old.
right. So we got no drugs unless prescribed, no alcohol, no weapons, no further contact with Giuliani, Juliani, Tavares, Tavarez. Stay away from Champions Glen Apartments at 6425 Oakley Road in Union City. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. You have to supply that to the ankle monitoring company and to your lawyer. 10, 10, 10, and 3. 10, 10, 10, and 3. Best of luck to you, sir.
Your Honor, is there any way we can review the ankle monitor later?
Absolutely. Absolutely.
Because he has a good job and he has a home to live in. That's the only reason I was.
I tell you what, why don't we make it one of these Teletrix monitors? Because that's looks more like a smartwatch.
Okay.
So make it a Teletrix, Miss Rowe. Okay.
Got you, Judge.
All right. Thank you, sir. Best of luck to you. You can leave the booth.
Thank
All right,
you,
we
Your
got
Honor.
Alan Hall. Alan Hall. Wave your hand if you're Alan Hall. No Alan Hall. What about Antoine Woods? All right, there we go. 22 CP 207606 is position 10. 408 days without indictment. There is a $64,000 good bond as of June 27th, 2022. Hijacking motor vehicle, possession of a firearm during the commission of or attempt to commit certain felonies, possession of scheduled controlled substance 1 or 2, obstruction of a law enforcement officer. Rah!
5 prior arrests, took a first offender on theft by receiving stolen property in 2018. Nothing further.
All right. Go ahead, Mr. Lyle. You're on mute.
I guess the button didn't press. Yes, Mr. Woods is age 22. The address on file on Phillips Drive, Southeast in Atlanta is good. He has a 12th grade education and he had been working at a warehouse with FedEx and DHL before his arrest. He does have family in the area, his grandfather and his uncle, and he would be living with his grandfather at that address on the file. His preliminary was in January this year, but there's still been no indictment, and this case was brought last March. So we are requesting a substantial reduction in the amount from $64,000 to closer to $35 to $40.
All right. What says the state, Ms. Patton?
Yes, Your Honor. The state feels the bond put in place, $64,000, is reasonable considering the defendant's history. However, if Your Honor is inclined to reduce the bond, we ask that the same conditions be put in place that are on the original one. That's a stay away from incident location and no contact with victims, Eddie Thomas and Javante Johnson.
All right. And I've already put this, I've got my email going. This is the first one in there, 408 days without indictment. So we got no drugs unless prescribed, no alcohol, no weapons, no further contact with Eddie Thomas or Javante, Givanty Johnson, no further contact with your co-defendant, Damian Shaw, SHAW, stay away from 3550 Campbellton Road. I think I already said no drugs, no alcohol, no weapons. And he's going to live in Fulton County?
Yes, Your Honor, it's in Atlanta.
All right, you're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, or employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. You have to give that to the ankle monitoring company and to your lawyer, so you can't just get a job, tell them you're working, and quit it, and then act like you're still going to work. Hint, gentlemen and ladies, they send reports to the DA's office on a monthly basis, so if you mess up, you get your bond revoked. 40,000, 5,000, 500, and 2,000. 40,000, 5,000, 500, and 2,000. Best of luck to you, sir. You can leave the booth. All right, Christopher Moore. Wave your hand. Is that you, Mr. Moore? All right, thank you, sir. So we got Christopher Moore here. It's position 16, 22 CP 209-524. 755 days without indictment. There's a $45,000 good bond as of January the 9th, 2023. And I know it's not 755 days on this. He's in on other charges. Aggravated battery, right in a penal institution, affray, and disorderly conduct. That $45,000 good bond as of January the 9th, 2023. Retrial.
Multi-state offender, 30 arrests in Kentucky, prior conviction of firearm by a convicted felon. In custody, I already took a sentence on the other case, 22 SC 1822908, terroristic threats, 2 counts, aggravated battery, aggravated assault, firearm during firearm by a convicted felon. Sentence 12/1/2022, 2 years confinement, 3 years probation. Nothing further.
All right, go ahead, Mr. Lyle.
Yes, Mr. Moore is age 39. He's lived in the Atlanta area for about 1 year. So he does have family in the area. He has 2 aunts and uncles in the area and his grandmother, who he helps take care of. She's housebound to arthritis and some asthma and stomach ulcer issues. So he does take care of them. He also has 2 kids, a 13-year-old daughter and a 14-year-old son, who live with the grandmother as well. He's got a GED from a school in Kentucky, and he owns his own business, the franchise with the Jan Pro Cleaning Company that he can return to once he is out. His address is in, let's see, Lawrenceville, Georgia, that he could stay with. That's his uncle's address, David Wright, who I've been in constant contact with.
Not exactly.
So as this case has been in the system for quite a while, I know that it says 7 days on the calendar that he's been in for other charges, but those other charges are now finished. So these are the only. This is the only charge holding him in prison at this point.
All right, and I went ahead and did the. I put this one on my email.
Yes, thank you. So we are requesting reduction to a total of 20,000 or less.
All right, Ms. Patton.
Yes, Your Honor. The bond that's been put in place for these specific charges, the aggravated battery, riot, and disorderly conduct, we think is more than reasonable and fair, considering the fact that he was in on other charges and still did not obey the rules of the jail. There's a likelihood of reoffending and a danger to the community based upon the fact that he's not following law enforcement officers. At this time, we would ask the state recommends that the bond in place stay in place.
All right, no drugs unless prescribed, no alcohol, no weapons. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, probation officer visitation if you got probation on the other case, and employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. No further contact with your co-defendant, Harold Norris. No further contact with Ricky Sheets, SHEETS. Stay out of Fulton County, sir, since you live in Lawrence unless you're here for court, lawyer, or see if you're on probation, see your probation officer. Don't fill up with gas before you come down here. Don't get a snack, throw a snack in your car. Don't get a flat tire. Don't do any of that. Stay up in Gwinnett County or anywhere else. 20,000, 5,000, 1,000, and 1,000. 20,000, 5,000, 1,000, 1,000. Best of luck to you, sir. You can leave the booth. Thank you, Cobb. All right, Cortez Ragland. There we go. This is position 16, I think, or it's a different one. Wait a minute, let's see.
Are you telling us it
He
gets
has
worse?
two positions, Your Honor.
Let's see. I think one of
18 and
them.
19. 18 and 19.
It's
Yeah.
always fun hanging out here, but it's been relatively calm today.
All right, 1 second.
Good thing I had that Karen walk into Washington, into Thurston County there.
All right, here we go. All right, so we got 22CP214680, Cortez Ragland, 166 days without indictment. Entering automobile with the intent to commit a theft or a felony therein. As of December the 15th, no bond. Then we got 22CP214059, 166 days without indictment, no bond as of 11/23/2022. Entering auto with intent to commit a theft or a felony therein. Theft by receipt of stolen property, entering an auto with intent to commit a theft or a felony, possession of firearm during the commission of or attempt to commit certain felonies, possession of tools for a crime, possession of a pistol or revolver by a person under 18, first offense, unlawful for a person employed by, associated with criminal street gang to conduct or participate in criminal street gang activity, times 2, 3, times 4. Gang charge times 4. Preach! Rah!
3 prior arrests, hold indicator for trespass, open case 21 CP 200-291. Armed robbery, aggravated assault, firearm during theft by taking, 21 CP 200-452. Armed robbery, theft by taking. Nothing further.
All right. Go ahead, Mr. Olaf.
All right, thank you, Your Honor. Mr. Ragland is 17 years old. He's a lifelong Georgia resident. His entire family lives here. Should he receive bond to be released, his address would be Sims 87th Street. That's Atlanta, Georgia. That would be Fulton County. I need to file a change of address on that. He'd be staying there with his mother. He's currently in the 11th grade and plans on graduating. And he was working with his father with a tree removal company before he was arrested, and he can return back to work there. We just asked for a reasonable bond in this, Judge. Thank you.
All right, Ms. Olivier.
Thank you, Your Honor. Judge, Mr. Ragland was caught with 2 other co-defendants breaking into cars in a residential neighborhood, and he was identified by the victim. The 2 co-defendants are known gang associates of YSL. Mr. Ragland's a known gang member. He's in Down for Whatever, Born Rich. The defendants did travel to that incident location as well in a stolen vehicle. And when he was found,
I jumped for a second because I thought she said Mr. Gravlin, and I'm like, all right, what did I do now?
he had a 9mm firearm and rubber gloves used to bust out windows in his possession. Also, at the time of the incident, he had a pending armed robbery and also a pending theft. We think he's a risk to reoffend and a danger to the community, but we do understand that he's entitled to a bond at this point. So we would ask for a total bond of $451,000 with $10,000 on count 1, $10,000 on count 2, $10,000 on count 3, $10,000 on count 4, $10,000 on count 5, $1,000 on count 6, and $100,000 on each of the gang charges.
Go get them,
With
Larissa.
GPS and 24-hour monitoring. Stay away from the victims. That's Elijah Irvin and Kobe Dixon. Also stay away from the co-defendants, Quantez Walker and Francois Persard, and I can spell that for the court.
Okay.
Also, FRANCHOT, last name PERSAUD as in David. Also, no social media, no contact with any member of a criminal street gang, and no guns.
All right.
No fun.
And if I
No
may,
smiling.
88 Olivier, did you address position 19 as well?
The other entering out of.
I'm sorry, Your Honor, I wasn't aware that that one was on as well. But it looks like he's also entitled to bond in that case as well, Judge. And we would just ask for a bond in the amount of $20,000 on that case. I don't see that that one has associated gang charges at this point.
Yeah, no ma'am. All right, let's see. On 22 CP 214680, no drugs unless prescribed, no alcohol, no weapons, no further contact with Orlando Swaby, SWABY. Stay away from 1400 Donnelly Hollowell Parkway. You're going to have a teletrix monitor paid for by the county with a 24-hour court curfew, court, lawyer, and medical. And he says he wants to get his GED. So school, as long as he provides proof of enrollment and that he's going, $10,000 good bond.
Wouldn't that be all
On
online?
22 CP 214059. No drugs unless prescribed, no alcohol, no weapons. No further contact with your alleged co-defendants, Cortez Walker and Fred Schwab Prashad. You're going to have a teletrix monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and school, as long as you provide proof of enrollment and that you're actually going. I think I already said no drugs, no alcohol, no weapons, no replicas of weapons, no further contact with anybody in the Down for Whatever Born Rich gang or any other gang members. No social media. No further contact with Elijah Irvin, ERVIN, Kobe Dixon, DIXON, or Lakin Patton, PATON. Come, that teletrax monitor is paid for by the county. So I've got 10,000, 10,000, 10,000, 10,000. Possession of tools for a crime, 1,000. Possession of a pistol by someone under 18, 5,000. 100,000 per gang charge. So I got 10,000, 10,000, 10,000, 10,000, 1,000, 5,000, 100,000, 100,000, 100,000. Best of luck to you, sir. Got that, Miss Jamie?
Yes, Judge, I got it.
Thank you,
Thank
ma'am.
you.
You can go ahead and leave the booth, sir.
And Judge, that's all my business. May I be excused?
Yes, ma'am. Thank you.
Thank you.
See, do we have them back for, oh, there we go.
Yeah, you got ACDC on this.
All right, so Mr. Mustafa Kareem, or that you, sir?
That's me. I'm here, Your Honor.
I'm talking about to Mr. Kareem Mustafa. Is that you? Wave your hand. All right, thank you. All right, position 923 CP 215439, 108 days without indictment, trafficking in cocaine. There's a $50,000 good bond as of 1/4/2023, and it was 58 grams. Oh, well, it's trafficking cocaine, marijuana, or methamphetamines. Allegedly 58 grams of methamphetamines. 108 days without indictment. Pre-trial.
27 prior arrests in Georgia, 6 in Ohio. Couple of FTAs, 7 arrests, probation violations, 2 for parole violations, 3 misdemeanors. Currently on probation, 16 SC 142, 308. Cocaine with the intent, no insurance, expired license, sentence 5/11/16, 1 year confinement, 9 years probation. Also took PTI in 2014 for cocaine. Nothing further.
All right, go ahead, Mr. Parker.
Good afternoon, Your Honor. How are you? Good to see you again.
Good to see you again.
Your Honor, Mr. Mustafa Kareem had a previous bond amount for $50,000. We asked that the conditions remain in play. Only thing we asked for a reduction to $25,000 or reasonable bond, so Mr. Mustafa can get out of jail and assist in his defense, get back to work, and also abide by the conditions and the previous bond order that was put out a couple of months ago.
All right. Go ahead, Ms. Patton.
Yes, Your Honor. In this case, a $50,000 good bond was in place for this defendant. The state at this time feels that that is appropriate, reasonable, and fair due to his likelihood to reoffend, multiple FTAs on his history, and that's all. Nothing further from the state.
All right. No drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Also, no further contact with your co-defendant, Harlan, Harlan Fisher, Fisher. Is he going to live in Fulton County?
He's going to be in Stone Mountain, Your Honor.
All right, good. Stay out of Fulton County unless you're a court or to see your lawyer, sir. Don't run out of gas. Don't
All right,
get a flat
good.
tire. Throw a snack in your car. Don't stop it at Chick-fil-A, Chipotle, or any of those good places down here. Hopefully you got them there. $35,000 good bond. Best of luck to you, sir. Thank you, Mr. Parker.
Thank you, Your Honor.
All right. Let's see. I've got Justin Harris. Wave your hand if you're Justin Harris. Oh, got you. Okay. So we got 22 CP 213465. 119 days without indictment.
It'll be interesting to see how long
Without
Kim
indictment,
lasts.
got terroristic threats and acts, 3 counts of criminal damage to property in the 2nd degree. Did alpha bonding come off of this, Ms. Woods?
Your Honor, I'm not aware of that. I was just in court, Your Honor, and my understanding was the only case that he did not have bond on would have been his aggravated assault, and we just received bond on that. So I'm actually not sure about this case.
So yeah, because it says Alpha Bonding it posted the bond for 16.5. Is that, sir? Give me a thumbs up. Are they still on your bond? Okay, so I can't hear you talking. I just need a thumbs up or a thumbs down. Are they still on your bond? No, he doesn't know.
He doesn't know.
And I don't see anything in here. Ms. Woods, if you figure out it's something different, let us know.
Okay.
And we can get it back on our next private attorney calendar. I don't see a note on here, but
The last time I saw an Odyssey, Your Honor, I did see that case had a bond.
yeah. Yeah. Let's see. And it was actually, let's see. Let me make sure. One second. Let's see. Well, it actually says this one was 9,500, but it says there's a 16.5 good bond that's been posted. Doesn't make sense. So,
okay.
But let us know, okay?
Okay, I will, Your Honor.
All right. Thank you, ma'am. Have a good evening.
All right, thank you.
You can lay the booth, sir. All right, we got Alan Hall. All right.
Judge,
Yes.
are you saying that they paid the aggravated assault and brought in the penal institution?
She left. She said they just heard it today and did it.
Okay.
She said somebody else heard it. It wasn't me that heard it today.
Okay, because from his booking, the two things that's holding him in custody is the entering in the aggravated assault case. Okay.
Yeah,
All
she
right.
said they just addressed that today.
Okay.
All right.
So what happened to the judge? What happened to the 465? Was that one removed as well?
465 on here says he's already posted that bond.
Okay.
Justin Harris. So yeah.
Okay.
All right. Alan Hall, 23 CP 215744. 96 days without indictment. There's a $15,000 good bond as of 1/27/23 for theft by shoplifting. Wow.
Extensive arrest history, 75 prior arrests, repeat offender, at least 8 felonies from aggravated assaults, false report of a crime, armed robberies, financial transactions, couple of felonies, at least 7 arrests for probation violations, 13 misdemeanors. 1, 2, 3.
Come on.
7 of them being theft by shoplifting. It's nothing further.
All right. Go ahead, Mr. Law.
Yes, Mr. Hall is age 69. He was born in DC, but lived most of his life here in the Atlanta area. He has siblings in the area that he's sometimes getting in touch with. Now he didn't have a job before he was arrested because he had just been out of jail given his history. But he does have numerous medical issues, including seizures, and has to be transported to Grady often. And I know the warrants typically aren't brought up in this, but the diversion supposedly in this shoplifting case was a seizure, which he does have medically conditions for. His address would be in Atlanta, Georgia, at his stepmother's address on Azalea Street. So we're requesting a reduction to $5,000 bond so that we can potentially get him a bond project bailout.
All right. What says the state?
Your Honor, based upon this defendant's history, the state feels a $15,000 good bond put in place by Judge Hughes is more than reasonable and fair.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 675 Ponce de Leon Avenue Northeast. No further contact with your co-defendant, Rasheen, Rasheen, Garvin, Garvin. You're gonna have an ankle monitor paid for by the county, 24-hour curfew, court, lawyer, medical, or employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working, sir. You have to do that, give that to the ankle monitoring company and to Mr. Lyle. $10,000 good bond. Best of luck to you, sir. 10,000. All right. What about Aaron Montfort? Thank you. Mr. Hall, you can lead the booth. All right, this is position for Mr. Montfort. Position 8. 23 CP 215665. 99 days without indictment. No bond as of March the 22nd, 2022 for aggravated assault. The incident date was 11/14/2022. Pre-trial.
With regards to Mr. Montfort, 3 prior arrests, open case 22 CP 212526. It's an aggravated assault, same victim, and he was supposed to stay away from the same location, 411 Holly. Nothing further.
All right, Mr. Lyle, and this victim's allegedly his brother.
Yes, Your Honor. Mr. Montfort is age 29. He's lived in the Atlanta area for the last 6 years. He does have extended family in the area. He has 2 children, a 10-year-old boy and a 5-year-old girl. He completed high school in 2012 at Charles Andre High. He had been working with the Pitney Bowes company through a temp agency, which was just mailing and various sorts of packaging.
Proud graduate of Charles Andre.
He would be able to stay at 1247 Joseph E. Boone in Atlanta, Georgia. He does have some history, but it's fairly limited. So we're requesting that he be given a bond of $20,000, which is pretty standard for aggravated assaults.
All right, what says the state?
Yes, Your Honor. The state in this case is looking at the danger to the victim, considering that these 2 incidents, I'm not going to get much into the facts, so I will observe that rule. But this is the same incident, same victim, same incident location as pretrial mentioned within a very short time of each other. At this time, the state is recommending a $25,000 good bond based upon the danger to the victim.
All right, no drugs unless prescribed, no alcohol, no weapons. You got a Teletrix monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. You're going to have supplied to the Teletrix monitoring company and to your lawyer, sir. Stay away from 411 Holly Street Northwest. No further contact with Isaiah Montfort, Montford. $20,000 good bond. Best of luck to you, sir. You can leave the booth. All right, Antoine Bird.
What did she give him?
Bird.
I'm sorry, Judge, did you say 24,000?
20.
20.
She asked for 20.
All
He
right,
asked
we
for
got
20.
22 CP
She asked for 20. She asked for
210852.
25.
284 days without indictment. There is a $5,000 good bond as of October the 25th on entering an auto or other motor vehicle with intent to commit a theft or a felony. Preach, rah.
Your Honor,
Bird,
he's my
multi-state offender.
Go ahead, Boston.
Multi-state offender, Michigan, Florida, hold by the FBI, 5 prior arrests here. Open case 23 SC 187351, riot, battery, ag assault, assigned to Judge Eaton. Nothing further.
My
They hold from
God.
FBI.
Do these people ever just commit
Yes.
one crime and be done with it?
Go ahead, Mr. Wiltshire.
Thank you, Your Honor. Good day. And Your Honor, I'm just putting on the record, Your Honor. I have tried contacting this client. We have absolutely no contact information except a mailing address, even send letters and that sort of thing. No return. Tried getting from the Fulton County office any of his whereabouts. Nothing has been returned, Your Honor.
Oh, Ahmada's got a cool island
He's at the
accent.
jail. I don't understand what you mean you haven't had contact.
Your Honor, we've tried to even contact him via I get clients through Joy, Your Honor. I've even tried looking on the Georgia Department of Correction and the Fulton County Jail, Your Honor. And his information was not coming up, Your Honor.
He's in 4 North, cell 514. Have you went to the jail?
Beg your pardon, Your Honor?
Have you went to the jail?
Have you gone?
Oh, Your
What are
Honor,
you
I'm
doing,
so
Judge?
sorry, Your Honor. I just mixed up files, Your Honor. I spoke with him. I spoke with this client via the video calling feature. I do apologize, Your Honor.
Okay.
I do
Oh, he's shaking his
apologize,
head.
Your
No,
Honor.
you didn't.
No,
Mr. Bird, wave your hand. Well, that's your client. Do you know him?
no, Your Honor. I'm so sorry, Your Honor. Your Honor, this file that was sent to me, Your Honor, I tried finding his information, Your Honor. I do apologize, Your Honor.
I'll let this guy get away with
So
anything
he's
with
in
that
Wright
accent.
Street. 4 North. What did I just say? 514. Isn't that right, Mr. Bird? There you go. That's his location. So you're not wanting to go for it on a bond. He's got a $5,000 bond. What do you?
Your Honor, we will not contest a $5,000 bond, Your Honor.
So that's what it's set at now. Ms. Patton?
This client's not happy.
Yes, Your
I
Honor.
would
the
have said
state,
make it
deems that more than very
2. I don't
reasonable
care if she
considering
denies
his
it.
History, a $5,000 bond would be what the state recommends in this case.
No drug. Sit down, sir. I'm not finished. You gonna live in Fulton County?
The defendant is so disgusted, he just gets up and walks out of the booth.
Up or thumbs
Oh,
down? You gonna live in Fulton County?
sometimes it's too fun.
No, all right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Lorana, Loran, last name Hygema. Stay away from 1245 Oakley Industrial Boulevard. Stay out of Fulton County this year for court or to see your lawyer. Gonna have a Teletrix monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, or employment, as long as you supply the name of your employer, proof of employment schedule, the exact location you're going to be working. All right, think I said no drugs, no alcohol, no weapons. You have to supply an address where you'll be living upon release to the jail staff and the clerk's office. You gonna live in Georgia, sir? I'll make that an ankle monitor, Miss Rowe.
Got it, Judge.
Yeah, make it ankle monitor instead of Teletrix and a 24-hour curfew. So you have 48 hours to have that placed on your ankle once you get released from that FBI hold. $3,500 good bond, 284 days. Best of luck to you, sir.
Is he to stay out of Fulton County too?
Stay out of Fulton County this year for court or to see your lawyer. Sir, I just went down. It was at 5,000. I went down to 3,500. That's a lower amount than 5,000. Last time I checked. I'm not real good at math. Best of luck to you.
Okay.
You can leave the booth. All right, Clarence Marsh. All right. Position 12. Let's see.
Oh, that's sweet.
Good afternoon.
Afternoon. All right. We got 23 CP 215530. 105 days without indictment. We got a 1,000.
I mean, the attorney was fine. He was frustrated. I don't know if he's like not being honest or not, but like he saw, like, he didn't talk to him. But then they say there's a $5,000 bond on it. I don't care. I don't even do criminal. Ask for less. Ask for less. Just say, Judge, I'd like reduced to personal recognizance or one or two. Then you've got the prosecutor arguing to keep it. There.
$1,000 split bond.
This isn't rocket science.
As of January the 18th, 2023, possession of cocaine with intent to distribute, possession or control of a controlled substance in Schedule 3, 4, or 5, possession of manufacture, distribution, sale of marijuana, PGCSA Schedule 1 or 2 controlled substance, possession, manufacture, deliver, distribute, possess with intent to distribute MDMA, possession of drug-related objects. Allegedly, 15.5 grams of MDMA, 10.8 grams of Adderall, 10.5 grams of weed, and 2 bottles of promethazine. Pre-trial.
14 prior arrests, 2 misdemeanors, 1 FTA, 1 arrest for parole violation, 3 for probation violations, 2015 firearm during and robbery, and another robbery. Nothing further.
All right. Go ahead, Mr. Melnick.
Thank you, Your Honor. Good evening. Mr. Marsh is 32 years of age. I'm sorry, Judge. He will be living in Fulton County upon his release from custody. He has 2 minor children that are dependent on him that have missed him for the last 3.5 months as he's been remaining in jail. Both of them are 5 years of age. One of them has special needs, and Mr. Marsh has been very supportive and has helped out in that situation very, very much, according to the mother of his children. All of his family lives in Fulton.
Oh, he's very supportive of the special needs when he's not dealing with his pharmacy. Oh, please.
County, Your Honor, his mother, the mothers of his children. He has siblings that live here, and he's had multiple family members who have been in continuous contact with me, inquiring about his case. He went to Douglas High School and completed the 11th grade. He is going to be gainfully employed upon his release from custody.
Absolutely.
E&O Auto Repair,
Hey,
which is over there off of Donald Lee Hollowell Boulevard.
All right. Ms. Patton?
Yes, Your Honor. Mr. Marsh is entitled to a bond. As such, I was just going to say the numbers down the line if that would be easier. 5, 2,500, 1,000, 5, 1,000, all good bonds.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Myesha Brown, your co-defendant. Myeshia, last name Brown. Stay away from 1575 Joseph E. Boone Boulevard. Ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. You have to give that to your lawyer and to the ankle monitoring company. 5,000, 2,500, 1,000, 5,000, 5,000, and 1,000. Need that again, Ms. Rowe?
Yes, Judge, I do.
5,000, 2,500, 1,000, 5,000, 5,000, and 1,000.
Thank you.
All right, best of luck to you, sir. Thank you, Mr. Melnick.
Thank you, Judge.
All right, Deontay Hampton. All right, Mr. Hampton. 193 days, 3 days without indictment, no bond as of November the 18th on 22 CP 214263. Deontay Hampton, aggravated assault, possession of a firearm or knife during the commission of or attempt to commit certain felonies, misdemeanor obstruction, unauthorized possession of prohibited item by an inmate. Pre-trial.
28 prior arrests, open case 21 CP 1 SC 179329, aggravated assault, false imprisonment, theft by taking, battery, family violence, cruelty, and third obstruction. Signed to Judge Cox in judicial hold, 2 FTAs, 13 and 19, 1 arrest for probation violation, 1 misdemeanor, took a first offender on a robbery in 2015, cocaine in 2015, theft by receiving in 2020.
You're better off
Took time served on
giving
the
an
theft by
address
receiving
outside of
stolen
Fulton County
property
so she
through
can ban you.
23.
Oh, no
and
choice about it.
possession of meth in 2019. Nothing further.
All right, go ahead, Mr. Olive.
Thank you, Your Honor. Excuse me. Yeah, Mr. Hampton is 31 years old. He's a lifelong Georgia resident. His entire family lives here. Excuse me. He has a 10-year-old daughter that he helps take care of, and he needs to get back to her to help take care of her. The address he'll be staying at will be 319 Anderson Avenue, Atlanta, Georgia. I've filed a change of address for that already. I'll be staying there with his cousin. He's a high school graduate, and he went to St. Andrews University for 1 year. He's a construction contractor, and he can go back to work doing that should he be released. And he did volunteer work raising money for school supplies while he was out. We would just ask for a bond not to exceed $5,000, Judge. Thank you.
All right. What says the state?
Your Honor, due to the likelihood of reoffending based upon his history, the state is recommending, I'm just going to say the numbers again down the line, $20,000 good bond, $15,000 good bond, $500.
Here's raising money for school supplies. You know, he's pushing a stroller. He's burping the kids. Come on.
$100 good bond and a $5,000 good bond.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with your co-defendant, Daline, D-A-L-I-N-E, Collins, C-O-L-L-I-N-S. No further contact with Antonio Jacobs, Trey Trevion, T-R-E-V-I-L-L-I-O-N, Kenwood Campbell, K-E-N-W-O-O-D, last name Campbell, or Eric Bell. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working, sir. 20,000, 10,000, 500, and 5,000. 20,000, 10,000.
There was one more person involved in that, last name Calloway. I wanted to add that for a no contact with him as well.
Okay, what's his name?
Calloway is the last name. Give me a second to get the first name.
Okay, so it's 20,000, 10,000, 500, and 5,000. Let's see. Are you Mr. Langdon? Mr. Langdon, your case was removed because bond was addressed earlier. It was addressed like last week or so you can go ahead and leave the booth. Thanks, sir.
Yeah, I'm not buying it ever.
Then we got the bond modifications to go.
But what about Ibrahim?
We've got that one too, but they're waiving his appearance. Right, Mr. Fortis?
And Hinton.
Judge, I'll waive his appearance. I also have
Hinton's not, it was removed for some reason.
Okay.
Judge,
There's bond modification still, Mr. Fortis.
I understand, but I think I have another one that's not a modification. I have one that's a modification, but Flukas.
Ooh, I don't see a Flukas on here.
Yeah, it was home. I have a notice of it.
There's no Flukas on for today. You have a case number so I can look it up.
I'll send it to you in chat.
Okay, thanks.
The 88 patent, did you ever come up with that other name?
Still working on it.
All right.
Judge, and what did you say was the issue? Is Mason removed? I'm sorry, is that the one you said waive in presence?
No, that Ibram. We already took care of Mason.
Okay.
That was taken off.
Okay.
Your Honor, that was a, I did find the name. It's a lieutenant there. It just says C. Calloway.
Oh, okay. All right. So no further contact with Lieutenant Calloway unless it's in his official capacity.
And that concludes my business this evening, Judge. May I be excused?
Yes, sir. Have a good evening. Thank you.
All right, you the same.
All right. We got Siraja Jamal, Ibrahim. He's in DOC, right, Mr. Fortis?
That's correct, Judge.
All right. You can go ahead and leave the booth, sir. Thank you. All right. That's 23 CP 215287. So right now there is a $28,000 split bond with no bond on the first 4 counts of driving, fleeing, attempting to elude, possession of Schedule II controlled substance, manufacture, deliver, distribute, administer, sell, possess with intent to distribute controlled substance, tampering with evidence, felony, improper passing, improper lane change, failure to use turn signal, driving, speeding, aggressive driving, DUI less safe, driving, possession of open container with the driver, failure to have license on person, driving in emergency lane, littering from a motor vehicle, driving improper erratic lane change, driving within the gore barrier or section separating the road and highway, seatbelt violation, and reckless driving. Preach, ride.
31 prior arrests, 4 misdemeanors, 3 felonies, 4 felonies, firearm by convicted felon, prior cocaine with the intent, tampering with evidence, couple of FTAs, 3 FTAs, 2010, 11, and 14. 1 arrest for probation violation, 1 for parole violation. Nothing further.
All right, go ahead, Mr. Fortis.
Thank you, Judge.
It's a strong resume.
He's 31 years of age. He's been in Georgia prior to his arrest his whole life. At this point,
Judge, at 31, he's only got 31 arrests. Okay.
Judge, he was working prior to his arrest in digital marketing. He has a marketing company. It's registered with the Secretary of State. He pays taxes. It's been in existence for roughly 7 to 8 years. He hires temporary employees through a temp agency. His home office is in Georgia. I believe that he was on parole in this arrest. His parole got violated. I hope I have this right. It looks like he may not be getting out till 2024. That's based on calculations that I have, Judge. Don't quote me on that. I'm just looking for a reasonable bond by the time he
serves his time,
gets the parole. I mean, it's gonna, there's no reason to pile it on. A lot of misdemeanors on that case, Judge. I just asked for a real reasonable bond. He's gonna have enough time in anyway once he's done with that parole violation.
Is he going to live in Fulton County?
Judge,
Really, no idea.
Yeah, I'm not gonna have any idea. Like once he gets out, the address that was provided was in Fulton County. But what I can tell the court is it's going to be tough when he gets out because I don't know where he'll go at that particular point in time.
Okay. All right. What says the state, Ms. Patton?
Yes, Your Honor. I believe that there's only a bond needed on the first 4 charges. Is that correct?
Yes, ma'am.
Okay. Based upon his history, the state at this time is recommending for number 1, a $10,000 good bond, for charge 2, a $10,000 good bond, for charge 3, a $5,000 good bond, and for charge 4, a $2,500 good bond. I'm not sure exactly what the total is with the other ones.
Okay. So it'd be no drugs unless prescribed, no alcohol, no weapons. He was going 55, he was going 130 miles an hour into 55. So no driving during the pendency of this case unless his bond gets modified. And he'll have an ankle monitor paid for by the county with a 24-hour curfew. Court
Is 130 and a 55 frowned upon in Georgia?
lawyer, medical employment. As long as he provides proof of employment schedule and the exact location he's going to be working, and you have to provide an address, obviously, where he'll be living, and also to meet with probation or parole officer if he gets out earlier. So we'll do 10,000, 10,000, 5,000, and 2,500. 10, 10, 5, and 2,500.
Judge, one other thing on that ankle monitor restriction, I would ask the court that he have it on within 24 to 48 hours of release, only because I don't know what that would do with DOC, and then he gets back here and doesn't get it on in time.
Yeah, he'll have 48 hours to have it placed on his ankle.
Okay, thank you.
All right. Thank you so much. Have a good one.
I got one more with you, Judge.
Oh, on the bond modification, because that other case isn't on here unless she can find it. But
I don't know what
go
happened to
ahead. How
that guy.
about Janae Collins, Mr. Katz?
He'll get
Collins,
picked
you
up,
turn your camera on.
but there's
All
no
right, this is
dates
the
to
bond
it.
modifications, Bostic, 22 CP 211002, Janae Collins, aggravated assault, possession of a knife or a firearm during the commission of a felony. Anything I need to know, Bostic?
No.
All right, go ahead, Mr. Katz.
Afternoon, Judge. Good seeing you. This is the case you had granted bond back on July 28, 2022. She bonded out on the 30th, $75,000 bond on the aggravated assault, $25,000 bond on possession of firearm during commission of a felony, total of $100,000. Since that time, unlike a lot of the, I hate to say it, defendants, she has graduated 2 different colleges. She graduated both Clark Atlanta and Savannah State.
Thank you.
She's got dual degrees. She's in actuarial science. She has an associate degree in one and graduate degree in the other. She has now a job working in the formal business setting. She has not violated the terms and conditions of her bond order. We're almost coming up on a year. She has no prior criminal history. And we're asking you that she be allowed to have the ankle monitor removed. Being in a formal setting, it's kind of difficult to, if you're wearing formal clothes, working clothes, and having an ankle monitor on your ankle, doesn't look real professional, doesn't look real good for her. And she needs to have the opportunity to be able to actively engage with clients and so forth for the business she's going to be working for. So I would ask the court to allow her to have that condition of the bond removed and
She needs to pretend she's not a criminal sometimes.
everything else stay in place. She has done everything she's been told to do.
Hello, can you all hear me?
Who are you?
I'm Antonio Gleason. I'm the victim. I'm one of the victims in the
Okay, stand by. I'll call on you in a minute.
Antonio Clayton can also, Judge, say whatever he wants to say, but I got pictures of him with so many firearms and gang banging that it's not.
Your Honor, that.
Look, if we're gonna get,
And
also Michaela Murray here.
if we're gonna.
It's getting spicy.
This person has continuously been contacting my client and threatening her. She has not had any contact with him. It's actually the other way around. My client's a victim here, but in any way, she has done what she's supposed to do. And, as far as his credibility is in question, but I'm asking that her ankle monitor be removed.
But what about my credibility? Because I'm a
Whoa. If you talk and your camera's not on and you're not sworn in, you're not talking. Miss Patton, you obviously have people on here that you didn't talk to and tell them how we run this courtroom. And that's not just start running their mouth before I call on them.
Woo! We were cruising along, everything was fine, and then chaos breaks out. It could happen at any moment here. At any moment here in Judge Manning's room.
My apologies, Your Honor.
Go ahead.
Your Honor, the state would, in hearing what Mr. Katz has to say, would offer the suggestion of moving to a Teletrex, which is the one on the wrist that looks more like a smart watch. I do have 2 victims on here who would like to speak after they get sworn in, so I do not want to overtalk them. I do want to give them an opportunity to speak on this. They have both expressed, though, that they are still fearful of the victim and would ask that the ankle monitor or tracking device, like I said, if it was moved to a Teletrex, that's still acceptable, not be removed from Ms. Collins. If you would be so inclined, Your Honor, to let each of them speak, you tell me first.
To Katz's credit, he knew this was going to happen. He was ready for it. He had like pictures and stuff at the ready. He's like, I know where this guy's coming from, and I'm gonna hit him when he comes in.
As long as they turn their camera on and you swear them in.
Yes, Your Honor.
I haven't seen the cameras come on.
Murray? Miss Michaela Murray? I'm not sure she's able to unmute herself or turn the.
You unmuted before, but she
Yes, Ms. Patton, in your honor.
Hold on, ma'am, you got to turn your camera on. I have to see your face. You can't testify if I can't see your face.
Okay. I'm trying to. Your Honor, can you give me a second? I need to close the app out in a lot second.
All right. You want to call your other victim when she figures out the camera?
Yes, Your Honor. Mr. Gleaton, can you turn on your camera, please? Mr. Gleaton? Please unmute yourself so I can swear you in.
Okay, can you hear me now?
Yes, Your Honor, did you want me to swear him in or would you
Sure,
like
go
to?
ahead.
Please raise your right
Who's
hand.
seen this? Does this go sideways?
Do you swear that the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
You're not
Thank you.
driving, are you, sir?
No, I'm not.
All right, go ahead.
The judge here wants to know what you have to say regarding Ms. Collins removing the ankle monitor. Please keep your testimony limited and make sure that it is not
Go off track.
that you're staying on the same track. Thank you, Your Honor. I couldn't figure out where to say it.
But due to the nature of the crime and the co-defendants, I would not like the ankle monitor removed because, like I said, it was not only her who came to my place of living, but
Hold on, Mr. Clayton. All we're talking about right now is just her.
right,
Not
right.
the
That's what I'm
co-defendant.
saying.
It's just no, you can't talk over me. We have a court reporter.
I'm sorry.
So all I want you to talk about is just Miss Collins, okay?
Right. Well, I know. Well, she came to my place of living and shot at me. So I don't know what pictures of me gang banging or anything got to do with that. I am an artist and I do run a music label. So whatever pictures you saying gang banging, that's
Mr.
fine.
Gleason,
You know what I'm
Mr.
saying?
Gleason, that's unnecessary. Just tell Your Honor how you feel about her getting.
His expression was fantastic. Oh, it's good. He's like, oh, please. I'm an artist. I don't know what me gangbanging has to do with it. A lot. It has a lot to do with it because you're in a constant cycle of retribution. That's why.
Her ankle monitor removed. And
I don't like the idea of her having her ankle monitor removed because, like I said, the accident. I have mail. That was my place of living. I had my child with me. My son is 4 or 5 years old, and he's still talking about, Dad, don't go home, which I don't. I haven't seen my son since that day due to the fact his mother feels it's a danger to him of even being.
Just because I'm a bad father, not really having to do with this case at all. But I'm going to play it
with me because I had this young lady bring her and her co-defendants shooting at me, trying to kill me in my own, along with my girlfriend. So it's just like at the end of the day, it's okay.
4 or 5-ish.
She can, y'all can
there.
say she going to school,
Rugrat,
but I know what happened. You can say I'm gang banging, whatever you want to say, sir.
Hold on.
I'm sorry.
Hold on. Just settle down.
I appreciate your testimony. I think if I could summarize it, Mr. Glayton is adamantly against Ms. Collins removing the ankle monitor because of the danger, because of the fact that she's a danger to community and he has faced repercussions of not being able to have his son there. I would like to see if Ms. Murray would like to speak. That's all from Mr. Gleaton. If I summarized it correctly, please let me know. I just wanted to give Ms. Michaela Murray an opportunity to speak if I could.
Ms. Murray, if you take yourself off mute, you got to raise your right hand so she can swear you in.
Hi, Ms. Murray.
Hi.
Do you swear to tell the truth, the whole truth, and nothing but the truth regarding your testimony here today?
Yes.
Please tell the court how you feel regarding Ms. Collins and removing the ankle monitor.
I am against her getting her ankle monitor removed. I'm sorry.
Ms. Murray, I need you to stay still though. I need you to stay still.
Okay, sorry. I'm against her having her ankle monitor removed because of the nature of the crime. The defendant came to our home not once but twice, and after the authorities were called and before the incident happened, she was at my home the day before and she saw our child there. She saw, she basically came to my home multiple times to see how to commit the crime. So I don't feel safe with that happening and the incident happening twice. And
okay,
it seems like it's no stopping them, and it seems very reckless. And there has been other incidents after that with her family reaching out to me.
Hold on.
Ms. Murray,
I just want to know about her, not her family.
Yes.
We address the issue that's at issue, but if I may just summarize for you really quickly and let me know if I haven't covered it. It's safe to say that you are against Ms. Collins having an ankle monitor or any sort of tracking device removed due to the danger that you feel for you and your family. Is that correct?
Yes, I do.
Okay,
That
thank
is
you.
correct.
As both victims have stated, Your Honor, my suggestion was if she is going into a corporate job, I applaud that, but I still would enforce that a tracking device be on her. And it sounds like the Teletrix ones, they don't even cause any concern from any jobs. So that's the state's position at this time.
So here's my thing. Have you explained to them though that I mean, I've spoke with Judge McBurney and we don't keep ankle monitors on over a year?
Your Honor, it hasn't been a year yet.
No, it's a year at the end of the month.
Your Honor, I believe she got this in July, so we still have 2 or 3 months.
Let me look at the one she got out.
We got out July 30th, Judge. We gave her the bond on July 28th, but I said we're coming up on near a year without any problems.
All right, you can switch to Teletrix, and if there's no problems, you can get it off. Let me see let me look at the calendar. So write this up to switch it over to a Teletrix monitor, and let's see. Little calendar. As long as there's no violations and she's not arrested, she can get it off. Actually be July 28th. Wait a minute, July 24th. July 24th. I think that will make it easy. It's a Monday. That way, if there's any issues, you got a couple more days to work with them. But go ahead and submit it to me. Send it to make it a Teletrix monitor. It looks more like a smartwatch, ma'am. So you're really not going to necessarily be able to tell. It's kind of like I mean, I ran about 28 marathons, so it's got like it's more like one of the GPS smartwatches. Don't know if you're familiar. So you know, that's really all it actually looks like. So it's a little less offensive. Okay.
Thank
And
you,
then
Judge.
you don't have to sit there plugged up to the wall. I think there's a charger that you hook up and it's magnetic and you're like, stick it to it. Okay. Yeah. Just shoot me that and I'll get it to you. And then just call Teletrix. If you Google it, I think you'll find the number and work out switching it off.
Judge, do we all prepare the order and we just have to give that to the ankle monitor company, or how does that work?
You just prepare the order and shoot it to me and I will sign it and send it back to you.
Okay, I will. Thank you, Judge. Good
All right,
seeing
thank
you.
you. Thank you.
Thank you.
Thank you so much, Your Honor.
Thank you. Thank you, Ms.
Well
Murray.
done, Mr. Katz.
I forgot his, Mr. Gleaton.
I just liked Katz's indignation. He's like, okay, my client's done some stuff, whatever, they're bad, but these people the state are dragging in are absolutely no better, and he's right.
Thank you. Have a good day.
You too.
What
All right,
happens
so
in these
I've got
circumstances? But
Mr.
it's
Fortas.
funny.
I got Jawamba. Is that right? I probably destroyed that mate and made it horrible. I don't see your client on here though. Is he on here or she on here? Oh, there. You turn it on, Mr. Jawaba. You gotta turn your camera on.
Yeah, I'm just trying to figure out how to do that.
Oh, I'm all right. All right, this is 22 CP 213363 out on a bond for possession of marijuana or possession of controlled substance. Schedule 1, possession of marijuana less announced, theft by receipt, theft of mislaid property. Anything I need to know, Bostic?
No, Judge.
All right, go ahead, Mr. Fortas.
Judge, this is an unusual situation. So when my client was arrested and went to her first appearance hearing back on October 22nd of 2022, she was given a reasonable bond. The problem is she didn't get out right away due to her family being out of town. And so before they got back, I think that from my understanding, I did not represent her at that hearing, but they were concerned that she had not been bonded out for some reason. So in order to give her a much lower bond, I believe Judge George gave her an ankle monitor, but there's no restrictions. So just so they could lower the bond. So my understanding is there's no restrictions there. She's not being monitored. I don't know why, unless I have this completely wrong. I hope I don't, but we're asking that it be removed. And that's why there was really no purpose for it.
Ms. Patton?
Yes, Your Honor. I was trying to look up here if she had had any incidents like of it not being charged or anything. And Mr. Fortis, did you know about it?
Did I know about what?
Like, did you know if she's had any incidents of it not being charged or anything like that? I understand that there's no conditions, so it's a little hard to see what they're monitoring. I just was trying to make sure that she's been in compliance with it since it's been on.
I believe she's been in compliance. And obviously we filed the motion back in March. There's just I mean, the charges, Judge, if you look at them, I mean, they don't really there's not much about the charges either that would warrant an ankle monitoring device. It's a victimless crime.
I was
And
gonna say, I've never put one on and not put some conditions. I definitely didn't do that.
no, you didn't, Judge.
Yeah.
Your Honor, the state has no objection to that. I was just trying to make sure that there had been no incidents of further incidents since this has been put on.
And my understanding could not.
Okay. Ma'am, all right, this is a test. It's not whether they've been an incident, it's whether or not you're gonna tell me the truth. Take yourself off mute and raise your right hand. Do you swear affirm testimony you're about to give is truth, whole truth, nothing but the truth?
I swear.
All right. Have you forgotten to charge it or let it go, the battery die on it?
One time my charger just broke on me. I called them right away and they sent me a new one. Besides that, no, Your Honor, I've been very compliant with my requirements.
All right. Well, you were honest. That goes a long way with me. All right. Any objections, Ms. Patton?
No, none from the state.
All right. Appreciate you being honest. And you can go ahead and get me the order, Mr. Fortis, and we'll and they can remove it.
We need to kick her off. I'll talk with Mike. This Jumana made too reasonable of an appearance.
And Judge, do I send that to Ms. Robinson?
Yeah, or you can send it directly to me either way.
Okay, that's fine. All right, thank you. I'll drop that.
Thank you, Your Honor.
All right. Have a good evening. Hey, did you look at the other case, Ms. Robinson, that he mentioned?
I did. That case has been indicted. I sent him a contact number for him to contact.
All right. Thanks so much, Mr. Fortis. Have a good evening.
You as well, Judge. Good to see you, seeing everyone. Thank you.
All right, good to see you. Carla Robinson.
That's what we're dealing with here.
Mr. Lyle. This one is 22CP209754. She's out on bond for trafficking methamphetamine, possession of heroin, and possession of drug-related objects. Anything I need to know, Boston?
That the misdemeanor charge can be removed from pretrial.
Oh, the possession of drug-related objects? Okay. All right, go ahead, Mr. Lyle.
Yes, Your Honor. Miss Robinson is age 38, and she is a mother taking care of her children. She's trying to re-enroll in school and go out to find a job to take care of her children and live at a place that's not with her family. So she wants to live independently with her children and not impose on her family members. But unfortunately, her bond conditions that were set in October.
Say children one more time. I need Samuel L. Jackson here.
Require 24-hour curfew. So we're requesting that either the monitor be taken off entirely if possible. I know it's only been about 3.5 months it's been on. It was put on in February. But if we can't have the monitor taken off, we would request that the bond condition be changed so that it's a nightly curfew and that she's allowed to do schooling and employment as well.
If I put it on, I didn't put conditions?
And there are conditions, but the only exceptions on it are medical appointments, court appearances, and meetings with attorneys.
All right, so you want work and what else added?
Work and school.
Any objections, Ms. Patton?
No objection to work and school being added.
All right, you can add work and school.
Thank you.
And she has children?
Yes.
Okay, and then
I
she has to
believe the children.
remind her children if she has to take them to school. So basically,
Yes, of course.
necessities that you can
Teach
put that
them
on.
well and let them lead.
All right, thank you.
the way.
Just shoot it to me. All right, what about?
Okay, I'll do so.
And she can be removed from pretrial.
Yeah, and that misdemeanor
I feel you.
possession of drug-related objects, they can remove that from pretrial.
And put it UJR jail.
And make sure she calls into Boston 3 times a day.
That's a joke, Mr. Lyle. He looked real serious.
I don't know if the judge says so.
No, you can remove it from pretrial and make it a UJR to the jail.
All right, thank you, Your Honor. I will
All right, have a good evening. All right, Mr. Blevins. So I got Freddie Caldwell. It's position 5, 22 CP 214169. Out on bond for possession of cocaine with intent to distribute, possession of cocaine, BGCSA, possession of Schedule 1 or 2 with intent to distribute, possession, manufacture, distribution, sale of marijuana. Anything I need to know, Boston?
No, Judge.
It's not as good as pre-trial.
All right, go ahead, Mr. Blevins, what you need?
Thank you, Judge. Pretty much the same argument as Mr. Fortis made earlier. Mr. Caldwell, if you could turn your video on, please. I think he's on here, Judge. I just don't see him. But anyway, Judge, when Your Honor considered bond, we're asking to have the ankle monitor and the 24-hour removed. He had a pending charge in Cobb County. I think the court had looked at it. It's been dismissed. I have a copy I can share with the court if need be. He's 55 years old, and there's no victims in the case. He's a lifelong resident of Fulton County. He's lived in pretty much the same house, 210 Wadley Street in Atlanta, pretty much his whole life. And there's no one for him to stay away from, or he's not a flight risk at all. So we'd ask the ankle monitor to be removed, Judge, and the 24-hour curfew.
Let's see, how long has he had it on?
I believe Your Honor set the bond on February 27th.
Oh, so he just got it on.
Yes, Your Honor.
I mean, is he working? What's happening?
Yes, sir. Mr. Caldwell, if you can raise your right hand. Do you swear affirm the testimony about to give this court the truth, the whole truth, and nothing but the truth, so help you God? Or you have to take it off mute.
Well, other than that,
I do.
Okay.
and most of them aren't alive
you
anymore
lower hand.
anyway. So, I mean,
Are
seriously.
you gainfully employed now?
Yes, I am.
How are you employed?
I worked with LLC. LLC,
I mean, not that he's supporting.
a general contractor.
Okay. And does that take you out on job sites?
Yes, different job sites.
What type of work do you do with that general contractor?
Well, I do cleaning up, housing. It just depends on what the job is.
Okay. And is the hours irregular?
Mostly it's networking for my drug sales.
Are they normal hours, or just each job's different hours for you?
Varies, the time varies. Sometimes I'll be there about 9 o'clock. Sometimes early at 7 in the morning.
Okay.
Sometimes I get out about 5, maybe 6.
All right. Thank you.
Varies.
All right. Thank you, Mr. Caldwell.
All right. Ms. Patton?
Based on this defendant's history, I'm gonna have a recommendation of, if he's needing the ankle monitor to be off due to work, to move to a Teletrex monitor. The same, it's easier to hide if that's the concern here. Other than that, that is my recommendation from the state at this time, not to remove it, but to have it moved to a Teletrex so that he can work more efficiently.
All right, so we can do that, Mr. Blevins. We can make it a Teletrex monitor.
Thank you, Judge. And Judge, can we add in that he can go to church as well? I think just said work and
Should say like, let's see.
he said work,
Medical, employment, basic life necessities. Sir, I would just call, you got to call and let them know. If that's where you're going, you got to call and let them know. I'm not going to keep anybody from doing that, okay? But you got to call that monitoring company, Teletrix. Once you get it put on, talk with them. Say, hey, I'm going, going to temple, I'm going to church, whatever. Here's where I'm going, about here's how long I'll be gone, okay? That's most of them, just letting them know, and then letting Mr. Blevins know. So if anything comes up, he knows. Okay?
Okay.
All right. Get it to Mr. Blevins, I'll sign it, and then just reach out to Teletrix, and they'll and Miss Rowe, can you paste that in there? It has to be Teletrix, paid for by, so he'll know that's specific.
Where you want me to paste it,
I guess you
Judge?
can put it in the chat there to Mr. Blevins.
Okay, gotcha.
All right. Thank you, Judge.
Okay, thank you both
All
of
right,
y'all.
and Mr. Blevins is gonna submit the order, correct?
Right, Mr. Blevins, just shoot me the order whenever you're done.
Yes, ma'am.
All right, leave forehand.
That it?
Here.
Thank you, Mr. Caldwell. You can go ahead and leave. All right, so I got as position 6, 22 CP 211413.
Renee Rockwell's got some
Leave forehand.
wild
Aggravated
special
assault with
effects
deadly
going
weapon,
on.
possession of a knife or a firearm during the commission of certain felonies, possession and manufacture, distribution, sale of marijuana, criminal attempt to commit murder felony. Out on bond. Anything I need to know, Boston?
No, Judge, the misdemeanor charge can be removed from pretrial services to a UJR.
All right, go ahead, Ms. Rockwell.
Judge, can he work, please?
Mr. Forehand, I got to see your face, not your ceiling fan.
Oh, sorry.
Go ahead, it's not you. Go ahead.
That's a
He's
deal.
not used to this, Judge. Judge, he got out of jail on December the 5th. January, February, March, April, May.
Popsicle.
Do you think it's timely for me to request permission for him to attend interviews and work? He's got possible employment with construction, AHB, general contracting, and also flagship facility services, which is a janitorial service. We are requesting a change to allow him to interview and possibly work. If that does.
Ms. Patton?
Yes, Your Honor. I do have the
Howard?
victim in this case on line, and I want them to have an opportunity to speak if you should so choose to let them. In this case, while the modification is just to, oh, looks like we lost them.
Allow them to work.
Allowing to work. That sounds like it would be, the state would be amenable to it. I'm just wanted to make sure that the court was aware that the victim is still fearful in this case. So as long as it's strictly to work, then I think that would be acceptable.
That's fine. If we can switch it to the Talatrix monitor.
And Judge, I misspoke on the wrong person. He's not the person that was on pretrial. That's Takiria Jones.
Okay.
So
So
it's to report on Mr. Forehand.
all right. So if you want to switch it to a Talatrix monitor, Ms. Rowe, if you'll send Ms. Rockwell that also, that way the alleged victim can have that app where she can see if he comes, or they can see, I think it's a she or he.
It's a he. It's a
They
he.
can see if he comes within a mile of him.
Yeah, I remember
That doesn't
Rockwell now.
allow Mr. Jones to track Mr. Forehand, but if he gets within a mile of Mr. Jones, it'll let Mr. Jones know that Mr. Forehand is near him. So, and he shouldn't if he's just going to work. But he's got to supply his schedule and proof of employment. He's got to supply that to Talatrix and he's got to supply that to you.
Judge, so does it work?
Indeed
First,
it
we
is.
get the Talatrix in exchange for the ankle monitor, and then he would be able to interview, secure a job. And I don't know where the victim is allegedly working right now or anything like that. We would just, I will get with Madam Prosecutor on that and
Yeah.
let you know where he's planning on working and
Rockwell's a
et
hot
cetera.
mess. She
So
is.
I appreciate
And
She gets it done, but she's
call
just all
Talatrix,
over
they
the
should be able to work
place.
it out.
It's a
very
rambling
quick.
wreck.
Okay, can I get that in the chat? That phone number. This will be my first time.
Well, I
changing.
mean, you can look it up. You can look it up. I don't know the number.
Okay.
If you Google it though, it's Talitrix.
Okay.
Yeah, and Forehand, you want to sit down and be still? And not make me look at your ceiling fan, sir. No, sit down. There you go. Just like you're in court. All right, so so we can do that. And so it's Talitrix, okay? And if you call them, if you Google it, you call them, they'll work it out where you can swap it out.
Okay.
Are you even paying attention? Because you're looking off to the side.
So,
Did you see my
I
Kim
know his
Gardner
mom was
stream?
talking to him, Judge, a lot's going on. My question is because I don't really know. Does A&A All County, are they in charge of both?
Right. They actually pay both.
I see.
They actually pay both. And the difference between them is some of the, like the app when they're victims have that app that they can get from Talatrix and they can see, you know, if the alleged defendant gets close to them. So that's kind of different. So in some of the ones
Thank
where
you,
people are
Nicholas.
talking about, they're scared or something like that, or if it's, you know, a violent one, then I would, you know, agree to that. Or, and it is a smartwatch, so it doesn't look like the ankle monitor. So it's a little better for both and it makes both people feel a little bit better. Not that I'm still not slapping ankle monitors on people.
Thank you, Judge. Do I prepare that?
Yeah, if you want to prepare that, I think I think she put the wording in the chat for you. And I don't know how they wrote
Thank
up.
you so much.
I don't know how they wrote it up, but it's the same contract. They both just, it goes through the same people, but there you go. Yeah, get it to me and I'll sign it.
I can't believe I got all the way through this
Can I
call.
make a quick announcement on Takia Jones?
Well, you're the next one. What's your announcement?
Ms. Jones has already been released from custody.
Right. You had it on here for some sort of bond modification.
That's correct. At the time, she was having issues getting a bond because she's from a state with no bonds, but they figured it out.
Okay, all right, have a good one.
Thank you. You too.
All right. So, Ms. Rockwell, what did you say?
I will look in the chat to figure out what the language is. It will be the first time I'm moving from an ankle monitor to a Teletrax. I'll figure it out, Judge.
Yeah, I
If
think
not,
she
I'll
put the word, she put the wording in there for you, or she will.
Okay.
Right, I was wondering, did you want me to put in there in regards to the work, medical school? Is that what you want me to put in there as well?
You know what? Let me just say this. I'm happy to to wait an extra two days. I would love for the bond order to be correct. So
Yeah, I mean, you can put that.
Renee always gets it done. She's fine. But the entire time she's talking, I'm nervous. I'm just nervous the whole thing's going south. It works out, but I lack confidence. That's all I'm saying.
That in there and give it to her. So
Okay, I'm gonna put it in the chat. Thank you.
She'll forward you that and it'll give all that information. But sir, just so you know, all right, the alleged victim has an app. Like I said, it won't trace you or tell where you're at, but if you come within a mile of them, it notifies them. So I would just heed those words. So if you're supposed to stay away from them or stay out of Fulton County, if I put any of them, then I suggest you do it. Are we good?
Thank you, Judge.
We didn't say anything, so I'm assuming we're good.
Thank you, Matt.
Yeah, we're good.
Okay. All right. Yes, sir. All right. Thank you. Both of y'all stay healthy and safe. Once I get the order, I'll sign it. Anything else? Is that it? Thank you, Ms. Foran. You can leave. I guess that's the last case, right?
Yes, Judge.
All right. Thank you. Ms. Jamie.
Oh, good Lord, we got it done. I had the first thing lined up. And I thought if I'm in a mood, we'll do that. But I just thought we'd do part of it. We ended up going all the way through, which I'm glad we did because it's fun to just hang out with her. But I'm like, oh, nothing spectacular's happened, and then it did. Then it did. It got fun. It got fun on the backside. It really did. Always a good time with Judge Manning. Yeah, Roswell's fun for that reason. It's like she actually always comes through. I'll give her credit. Nothing horrible has ever happened when she's up there, but every time I'm like, whoa, what's going to happen here? Is she going to fall off her stool? She never does. She never does. They get to a reasonable result, to her credit, and we all carry on. But I'm worried for her, though. I'm pulling for her, but I'm worried the whole time. Oh, good Lord. Still, I say, although that had some great moments. I can't remember who was the other attorney who came in there. We had Island Boy who showed up and said, yeah, we're cool with the bond. His client throws his hands up and walks out of the booth. That's good stuff. But still the topper for the evening is the Karen in Washington who is being attacked by her landlord's vape and belittled by the noises they were making. It's too good. I was just like I had that going on in the background. I'm like, I'm not going to do a stream tonight. And then that came across. I'm like, I got to stream. This Karen is too fun. It's too fun. All right. Thank you all for coming out. Good Lord. It's 10:13 here in Chicago, here in the Windy City, where, by the way, it's still just bitter cold and a driving rain daily. That's what we're dealing with. Come on up. Come on up. It's about 42 degrees, sideways rain. That's pretty much been the weather for the last week. And it looks to be the weather for the next week. So, there you go. All right. I will see you all soon.